At a middle school track meet, a teenager throws a shot put, and it hits the dirt with a heavy thud. Usually, this is the part where parents cheer. Instead, parents start dialing their lawyers. The athlete is B.P.J. She is 13 years old, a straight-A student, and a transgender girl. Like a lot of kids her age, she wants to run cross-country and throw the shot put with her friends. But in 2021, West Virginia lawmakers passed House Bill 3293. The law requires student athletes to compete based on their biological sex assigned at birth, effectively banning biological males from girls' public school sports. B.P.J. and her mother filed a lawsuit, and a judge issued an injunction that temporarily froze the ban. While the case moved through the system, B.P.J. laced up her running shoes and joined the girls' team. Over the next few seasons, B.P.J. placed at the top of her events, winning multiple times and displacing hundreds of biological girls in the state track and field rankings. This local dispute quickly became a national proxy war. 27 states have now passed similar bans to protect female athletics, while the federal government simultaneously declares those same bans to be illegal discrimination. Teenage girls on both sides are caught in a conflict where state laws and federal mandates are in direct opposition, leaving the rules of the game in a state of constant flux. This legal battle is a collision of two protected American rights, equal protection and Title IX. B.P.J. and the Department of Justice rely on the 14th Amendment's Equal Protection Clause. They point out that B.P.J. has used puberty blockers and hormone therapy. They argue that banning her solely because of the biology she was born with is textbook discrimination. West Virginia answers with Title IX, the federal law passed in 1972 to ensure equal opportunities for women in education. For decades, Title IX carved out a protected, separate space for female competitors. The state argues that biological males possess inherent physiological advantages in strength and speed. In their view, allowing those bodies into female sports destroys the level playing field Title IX was built to protect. According to West Virginia, Title IX only works if sex remains a biological definition. This has created a legal paradox where the inclusion of one group is argued as the active destruction of another group's rights. This timeline shows how the lower courts fractured under the weight of this contradiction. The West Virginia ban was blocked, then upheld, then blocked again in rapid succession. The judicial instability pushed the issue to its boiling point, landing the case before the United States Supreme Court in January 2026. The inability of regional judges to resolve the paradox left the highest court in the land to make a final binding decision. Inside the Supreme Court, the justices were forced to wrestle with the uncompromising mechanics of competitive sports. In a race with 8 lanes, adding a 9th runner mathematically dictates a loss for someone already on the track. Because sports have a limited number of podium spots and roster cuts, the justices debated whether a victory for B.P.J. necessitates a loss for a biological female. This case began with one student athlete, but the Supreme Court's ruling will define the word sex for 330 million Americans. That definition is the load-bearing pillar for nationwide policies on sex-separated locker rooms, college athletic scholarships, and federal civil rights enforcement. If the law is designed to protect everyone, what do we do when protecting one person's identity means erasing another's opportunity?